2021 meeting of the Hillsborough County Land Use Appeals Board. I'm Richard Harrison, the chairman. As we always do, we will introduce the participants. In the adjacent room, we have Tom Hisney, Development Services staff, Sonia Rodriguez, Manager, Citizens Board Support. On the line is Cameron Clark, the Assistant County Attorney. Present in this meeting room are the Vice Chair, Ricky Bauman, and board members Jerry Campbell, Bradley Cornelius, and Peter Schwartz. Joining us virtually is board member Lawrence Smith, and our recording secretary is Joe Harless. I'm getting some feedback in here. Can we deal with that, please? All right, well, that's better. Thank you. I'll go ahead and read the rules that apply to the hearing today. This board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in Land Development Code, Section 10.03.03H, and consist only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. The order of presentation will be as follows: staff's introduction, the petitioner's case, the opposition case, and any rebuttal. Only the following have standing to appeal or to intervene in an appeal which is filed or may be heard at this hearing. Those are the applicant, the administrator, any person or entity which appeared before the LUHO and presented testimony or other evidence or presented evidence themselves or by proxy to the LUHO and was adversely affected by the decision of the LUHO. The board reserves the right to limit presentations to 10 minutes per side. The time may be extended for good cause. And pursuant to this reservation, the presentation is hereby limited to 10 minutes for each side, with rebuttal limited to 5 minutes. The board shall have the authority to uphold the land use hearing officer's decision or to remand the case back to the land use hearing officer. If the board remands a case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. The board reserves the right to pose questions to staff, the petitioner, or opposition at any time. The decision of the board will be rendered at the conclusion of this hearing and shall be reduced to writing. The decision of the board is final, but it may be challenged as authorized by state law by any person with standing. Ms. Rodriguez, if you'll administer the oath to anyone who's going to speak to us today and then call our first case.
Those of you who will be giving testimony, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
I do.
Be seated. Do you want me to call the case?
Yes, go ahead and call our one case for today.
Then the case that we have here is a continued case, appeal number 201340. The petition file number is variance 200951. The appellant is Stephen W. and Marcella G. Price. The property owners are Stephen W. and Marcella G. Price. The representative is Ann Pollock of Fletcher, Fisher, and Pollock. The petition request is to appeal the decision of the land use hearing officer who denied a variance for a third lot utilizing a septic tank in the urban service area. The location is 7205 Potts Road. The size of the property is 4 acres more or less. Existing zoning ASC 1, future land use RES 4, service area urban, and the date of the land use hearing officer was August 17, 2020. This case was continued from the February 5th hearing, February 4th, by the board, and again on March. Technical issues, just a moment. Try it again. Okay, appeal number 2013-40, petition file number variance 2009-51. The appellant Stephen W. and Marcella G. Price, they are the property owners as well. The representative is Ann Pollock of Fletcher, Fisher and Pollock. The petition request is to appeal the decision of the land use hearing officer who denied a variance for a third lot utilizing a septic tank in the urban service area. The location is 7205 Potts Road. The property size is 4 acres more or less. The existing zone is ASC1. Future land use RES4. Service area is urban, and the date of the land use hearing officer was August 17, 2020. This case was continued from the February hearing by the board, and again continued at the request of the appellant's representative at the March 5th hearing.
All right, thank you, Ms. Rodriguez. I guess let's hear the staff summary, please.
Sure. Tom Hisnay, Development Services. This appeal is for a denial of variance 20-0951, which sought approval of a variance to allow the subdivision of property in the urban service area to create 3 lots that would be served by septic tanks. The variance hearing was held on August 17th, 2020. The hearing officer rendered her decision to deny on September 8th, 2020. And then Sonia has summarized the appeal hearing history that brings us here today. I'm available for any question.
All right, board members, any questions for Mr. Hisnay before we hear from the parties? Don't see any, so Ms. Pollock, you have the floor for 10 minutes.
Thank you very much. Good afternoon, Chair and members of the board. I'm Ann Pollock, 433 Central Avenue in St. Pete, and I'm representing the owners and applicants. I appreciate this time to speak. It has been 4 months. The original hearing was actually in December. We're asking for this case to be remanded back to the LUHO for rehearing. A brief summary to refresh the recollection. The owners are seeking to utilize their existing entitlements to split their property into 3 discrete lots. The unified parcel consists of 4 acres with 2 existing homes on it. The homes were constructed in 1972 and exist today as legal nonconformity under the current code at no fault of the current owners. The owners wish to subdivide the 4 acres into 3 lots in order to construct a new home. County staff had told them before they can subdivide it, they first needed to come here to request this variance to permit the 3rd septic. This is a somewhat rural enclave within the county where there's no public wastewater anywhere nearby. The closest connection would be more than a mile away. With the approval of this variance, the next step would be for the owners to go through the subdivision process. What makes this site unusual, and what we do not think the LUHO took notice of, is that because the property has 2 homes on it, on a single lot, the owners are very limited in what they can do. As I'm sure you're aware, having 2 homes on 1 parcel is not allowed under current code, but the property is developed in a way that there's plenty of land to allow for a 3rd house. But because the property wasn't split in the past, we're here today. And I'm going to share my screen, which is the survey that's in the record. You can see this property here. If the property had been split into 2 lots originally when it was built, or let's say at any time in the first 10 to 20 years after it was built, you would have ended up with a smaller lot with 1 house here on the left, and a larger lot, a 2nd lot with this home here, generally, more or less. And that larger lot, under today's rules, would be allowed to split and would be allowed to have a septic. 3 septic systems would be allowed on the property, on the same area. No variance would be required. Nobody in the county would blink an eye. There would be no problem. But because out of no fault of their own, the owners have a property with 2 houses on it that were built long before they bought it. And now they have to go through this variance to get to the same situation of having 3 homes on this property. Other properties, including ones adjacent to theirs, have the opportunity to split and build new home because they're not in these unusual circumstances. And here's an aerial that was submitted into the record by the county. You can see the homes here. If the property had been split when it was done originally, they would not have these same concerns that they have here today. Here is a farther away aerial, and you can see the properties farther off. We can't split this area off here on the side because we have to address the nonconformity of the two lots on the property. So they have this hardship that really is unique and singular to the area and to the county, and that the LUHO erroneously ignored. She sidestepped the issue of the nonconformity by suggesting that the owners could just split the property into two lots, and that would resolve the nonconformity. But she completely avoided the fact that the nonconformity really is the hardship here. Other neighbors can split their property and gain another septic without this variance. And if these properties had been split, this property had been split correctly so that the houses weren't nonconforming, then they would be able to split it too. But they have a unique layout, they have a unique history, and because of this nonconformity, this hardship that they didn't create, they're in this position today. We ask, why should other neighbors be able to do this, but they can't just because of this situation that they're in? And we feel that the LUHO did not really recognize this, and we would like the opportunity to go back and further express it. The LUHO also erroneously suggested that the comp plan's limitation on septic has no flexibility, and that's incorrect. The comp plan and the land use code are very clear about permitting a variance in these situations when you've got a strict adherence to the rule isn't possible, and you've got no sewer service available. And in both these situations, that's what we're left with today. So the comp plan also has a policy directing that the most dense development occur in this area. They want at least 75%. And so building 3 lots on this property would, in fact, be consistent with the comp plan in terms of their effort to make this area more dense. We would respectfully request that you remand to allow this issue to be reheard by the LUHO. They do have an undue hardship. It's unique and singular, and the approval of the variance would result in substantial justice. We feel the LUHO misapplied the comp plan and the land development code and did not understand what the hardship is here, and instead took the nonconformity out of context and didn't recognize it as the hardship that it really is today. The owners have asked me to read their statement on this appeal solely regarding information within the record. And so I just wanted to do that, if I may. Stephen and Marcella Price say, we would like to utilize our property in a manner that is consistent with and in harmony with the neighboring properties while not infringing on any of our neighbors. We have been repeatedly frustrated with our attempts to comply with county procedures for over a decade. This frustration has been caused by conflicting instructions given to us by land use staff over the years. In 2019, Stephen attended a pre-submittal meeting with various members of the county to work through the process of subdividing. Multiple department heads gave their consent. Someone then looked at the property, which I'm sure you've all done, and I showed you the aerials, and determined that due to the unique shape of the property and the houses there, reparceling wouldn't be possible. And if you haven't had the time to look closer at the property and the surrounding neighborhood in question, we would ask that you do that today before rendering your decision. As was stated last time, the property is unique and unusual because it has 2 houses on this unsplit single parcel. There's plenty of room left for another house if we were allowed to split the property. This situation is unique to the neighborhood and probably the county, and the LUHO did not recognize this. Because 2 houses on 1 lot is a county nonconformance, we cannot build out the property without subdividing. We cannot subdivide the property without obtaining the septic variance for the 3rd lot. The path this process has taken us since that pre-submittal meeting originally, Stephen says, borders on which came first, the chicken or the egg. In order to reparcel, each parcel must have county road frontage. Due to the property's unique shape with these homes, this is impossible. Per county ordinance, a subdivision with an easement would be required. We were directed to split the property as a platted subdivision. A subdivision, however, is not allowed unless there are public utilities already available. And as you've heard, our little slice of Hillsborough County has no wastewater available. Therefore, we must request a variance to add one septic in order to complete the platted subdivision as directed by county staff, and to have 3 lots. We must show a hardship to be approved for variance, but the subdivision cannot be created without the septic tank variance. If one of the homes had been built on a separate lot, or if they had been split when they were originally constructed, we could now split the larger lot and build another home without requesting this variance. Due to the unique layout and history of the property's development, we do have a distinct hardship. Members of the board, we are asking for one variance for one septic tank inside a neighborhood that is 100% reliant on septic tanks. We understand there's a provision that would allow this request to be granted. It is not clear that the hearing officer took into consideration the evidence of the true uniqueness of this property and the hardship it has caused, therefore prohibiting us from developing our property in conformance with the county's own comprehensive plan and consistent with the surrounding properties. Since the request is not prohibited and is in harmony with the neighboring properties, we are asking you to approve this request to have our case remanded back to the original hearing official to be reviewed and subsequently approved. So with that, I'm here to answer questions. I think I would very much like to have this remanded so that we can address these issues, move this item forward. Thank you very much.
All right. So we have been doing, take board member questions in order. So I will call on board members, individual questions, and then we'll see where we get to after that. Mr. Smith, you've appeared on the screen, so let's start with you. Any questions for Ms. Pollock?
Yes, I have a couple. Ms. Pollock, you mentioned earlier that staff required you to do a couple of things before this. Did they also include that you should get the determination of whether the property was legal nonconformance? I can't find anything in your testimony. You talked about it as purportedly legal nonconformity. What is it?
We have not gotten an official determination. We were not asked to do that. In the discussions with staff, it was understood that it was likely to be legal non-conforming because the buildings were built prior to the date when the code went into effect. If it was felt to be appropriate, we certainly could request this. But because we were moving forward to subdivide, we would remedy any non-conforming situation anyway. And so it didn't seem necessary or appropriate to have to go through the bureaucratic process to get that determination.
Well, the LUHO did mention it in her finding of fact that you had failed to get that determination. It seems like there's plenty of time passed for that.
Well, I think that the issue
And
is,
my other, pardon me, my other question was, did staff direct you to get that?
no, we were not directed by staff to get that. If we had been directed by staff, we certainly would have done that. Absolutely. We have made every effort to comply with all county rules. And if staff directed that it was important and necessary, we would certainly have done it. And if staff going forward felt it was necessary, we would certainly request it.
I have another comment, and it's hard to work off all these screens here, but in your testimony, you actually said state law prohibits hooking up if you're over a mile. You had it in words just like that, where you said the state law prohibits the extensive sewer. You want me to find it for you? I thought it was kind of overreach.
Yes, if I said that, That was a
It's
mistake.
writing.
Certainly did not mean that there was any sort of, I mean, in order to develop, it would be required to connect to public sewer without getting a variance. So that would be a requirement, but the sewer system is more than a mile away. And, you know, they certainly don't have the resources to extend it. And I don't think the county would expect that. And as a result, the county had made a determination that because of the situation, sewer service was in fact unavailable.
Well, it revolved around the issue of hardship and the fact that the cost of something cannot be determined as a hardship by some state precedent.
Absolutely. And we would certainly recognize that the fact that they can't afford to do this is not something that is before you today. It is the issue that they have a situation where otherwise they would be allowed to develop with the septic tank if their property had been properly developed in the first place, that they would like to remedy this situation and use that third area to develop it. And they are not able to. It's as if sewer, when the county says sewer is unavailable, we look at that as sewer is unavailable, not that there's this opportunity to connect, to build it, to spend that money. That's not an issue. The issue is the hardship that they are suffering from, aside from the fact that the sewer isn't adjacent to their property. They are having to deal with extra regulations and extra requirements because of the way that the property was constructed. And that prohibits them from doing what any other property owner would do if the property were had just the single home.
You make it sound that the issue flips if there's not a sewer on the property line. What about if a half a mile away or 2,000 feet?
Well, I can't speak to that. That's something that would certainly be appropriate for the LUHO to address. But that was not something that was, part of the record. So I think what we are really looking at is we feel that there's more to this than that the LUHO saw, that we looked at the nonconformity as just a situation, but not truly as the hardship that it is creating for these owners, and that we would like the opportunity to remand so that we can have this further discussion. And if the issue of distance came up, then we could certainly address that. But in this case, the situation, the sewer line is where it is. It doesn't have access.
I have no questions, no further questions.
All right, thank you, Mr. Smith. Board Member Schwartz, any questions?
No questions.
Thank you. Board Member Cornelius, any questions?
No, sir, no questions.
Board Member Campbell, any questions?
No, sir, no questions, but I did find the testimony compelling.
All right, Vice Chair Bauman, any questions?
No questions, Mr. Chair.
All right, I've got a couple of questions, Ms. Pollock. You have referred repeatedly to the nonconformity and that your clients are seeking to cure that nonconformity. But the nonconformity could be cured simply by subdividing this into two lots, right?
If there was a feasible way to do that, that technically would cure that nonconformity. But we are certainly looking to do more than just cure the nonconformity. We're looking to be able to develop consistent with the surrounding area. And as a benefit of doing that, and of allowing us to do something that we would ordinarily have been allowed to do if the property had been constructed correctly, we're also fixing this nonconformity problem.
Well, right, but my point is, this isn't really about curing the nonconformity. It's about you wanting to get another lot. If you wanted to only cure the nonconformity, that's very simple, and your clients could have done that at any point. In fact, your clients could have divided this into two at any point, cured the nonconformity, and then come back and divided the lot in the way you propose today, right?
I believe that that would not necessarily have worked because of the process to do the subdivision. And that ultimately, we were told that that was not a feasible process because of the current rules for subdividing from a parent parcel. We would still need to bring in the third septic and get this variance. If that had been an option, we certainly would have moved forward in that manner. Like I said, we're trying to do whatever we can to comply with the regulations, just to allow us this opportunity to do what we could have done if the properties had been split when they were.
Well, and that gets to my next question. This is really the heart of your hardship argument. But it seems to me that your argument is somewhat circular. You have one lot with two homes on it, and your hardship argument seems to be, we can't do the things that we could do if we had two lots with two homes, or one lot with one home. So it seems to me the hardship argument is circular at best. And didn't the hardship already exist, or didn't the nonconformity already exist when your clients acquired the property?
Yes, it did.
Okay, so they bought one lot with two homes on it.
They did, yes. And,
Okay.
yeah.
So why, if that's the hardship, if the hardship is I've got one lot with two homes, why isn't that a self-imposed hardship?
Because they did not create the lot with the two homes. They did not, they own a property that has two homes on it, but buying the property itself is not self-creating a hardship. They have the property with two homes, and they would like to have the opportunity to split them so that they can develop as if the properties had been split correctly in the first place. But unfortunately, because of the house that has two homes, they're not able to go forward in that process without getting this variance. And we think that at a minimum, it would be appropriate for us to further brief the LUHO on this issue so that we can get a further discussion and further clarity on this issue.
Right, I understand. You've said several times you want a remand. I understand that. Are you aware of any instance of another property owner who had one lot with two homes being treated any differently than your clients were treated here?
Well, if I did, I don't know if that was introduced into the original record, so it wouldn't be appropriate to address that. But again, that would be something that we could, if we have that information and it wasn't addressed, or if we could get further information so that we could have a better fact information for the loop.
Well, I mean, you had your opportunity to present that information at the hearing if you had it. So that's all I'll say about that. That's all the questions I have. Any board members, before we hear from opposition, if there is any board members have any follow-up questions for Ms. Pollock? I don't see anyone in this room. Mr. Smith, anything further on your side?
I'm sorry, I was on mute. Yes, I would like to bring a follow-up to what you were just presenting, Mr. Chairman, that when a person buys a property that has problems in it, I believe there's some kind of case law that implies that that does follow to the new owner. So we've heard the defense that, well, these problems took place before we owned it. But, I don't think that really holds. You do your title search, you do all the search before you buy, at the buyer beware. I don't think it's just so easy to say anything that's wrong happened before we bought it, because there's no way to stop that.
Mr. Chairman? Mr. Chairman, sorry to interrupt, this time his name. The property owners are in the room and they're indicating that they would like an opportunity to speak.
Did the property owners speak below?
I'm sorry, sir.
Did the property owners testify at the Lujo hearing?
Oh, let me see, hold on.
They did not testify.
My name,
Hearing,
my
but-
name is Stephen
Sir,
Price.
sir.
All right, everybody hold on.
Can you address the question about who testified at the hearing?
I did not.
Excuse me, your representative will be answering. And-
No, he did not, but as the owner and applicant of the, he should be able to speak to the appeal.
I direct this, I'd like, yeah, there we go. Mr. Clark, County Attorney's Office, can you address the question?
Yes, Mr. Chair, I'd say that the property owner can speak, but it's important that the property owner, just like his representative, is limited to the record. I mean, he can restate something that was stated.
The record is wrong.
But he is,
All right.
he is limited to the record.
Right, of course. All right, so we're going to hear from the property owner, but your representative has already spoken and spoken for more than the allotted 10 minutes. So I'm going to ask that you not repeat things that we've already heard, because it seems like you're already into bonus time here. So we will hear from the property owner, but please keep it short, direct, restrict your comments to what's already in the record, and try not to repeat everything that your representative just told us.
And introduce yourself by name and address, please.
Yes, my name is Stephen Price. I'm one of the property owners at 7205 Potts Road. First of all, to correct the record, we did not buy the property. We inherited it from my wife's parents, who were the original purchasers and builder of the house. Okay, so that might clear that up. The adjacent property on the northeast corner, 4 acres, they have the opportunity to divide their property and get a septic tank simply because of the shape and location of their property. We're not asking to do anything different than anyone else has done in the neighborhood, but we are being punished simply due to the shape of our property. That is all. If the property were oriented so that it had road frontage, we wouldn't even be here today. We would simply split it and put a septic tank on it. Okay? We're being punished because of the orientation of the property. That's the hardship in my mind. It's the orientation of the property. We're not asking to do anything outrageous, illegal, or out of harmony from the neighborhood. We are just asking to have a third lot so we can build a third house. This was part of our retirement, was to have that third house. And this is going to significantly and adversely affect the income of elderly by not being able to split this property. This was the plan from decades back. It was just never implemented until now. That is all.
All right, Mr. Price, stand by so we can see if there are any board member questions, please. We'll go in the same order as last time. Mr. Smith, any questions?
No,
All right, Mr. Schwartz, any questions?
No questions.
Mr. Cornelius, any questions?
No, sir.
Mr. Campbell, any questions?
No questions.
Vice Chair Bauman, any questions?
No questions, Mr. Chair.
And I have no questions for Mr. Price. Thank you, Mr. Price. Anyone else to speak in support? All right, don't hear anything. Is there anyone to speak in opposition? Don't hear any opposition, so there will be no rebuttal. So that means, board members, it is now in our hands. This was the case that last time resulted in a 3-3 tie on the motion to approve the Lujo's decision, and then resulted in a 3-3 tie on the motion to remand. And we have the same 6 of us here again. So I have to say, I'm not sure where this is going to come out. But this is the point in the proceedings where we entertain a motion if anyone has a motion to make. Vice Chair Bauman.
Mr. Chair, I make a motion to sustain the land use hearing officer's decision.
The motion by the Vice Chair is to approve the decision of the land use hearing officer. Is there a second to that motion?
Mr. Chairman, I'll second the motion.
That motion is seconded by Mr. Cornelius. Is there any discussion, board members? This is our turn to talk. Any discussion here? If you're in the room, just raise your hand and I'll recognize you, and then we'll see what Mr. Smith has to say, and then we'll vote on the motion. Yes, sir. Mr. Campbell.
Yeah, I'm going to respectfully vote against the motion. I just feel like the applicant in this case, I don't see any harm in him going back in front of the Lujo and making this argument, particularly the one that Ms. Pollock expressed. But whatever the will of the board will move forward today, I hope.
All right, thank you. Any board member questions from those present here in the room? Ms. Bauman.
Well, actually, it's not a question. It's more of a statement. If bad decisions were made in the past, necessarily subdividing it the way the applicant wants to do it doesn't mean that that conforms with the way the county sees this should be subdivided. And maybe it should be in 2 lots or this and that, but I just look at it that they want it their particular way, and whether it was a plan for retirement funding or not, this was done by the family. And it's not even as if someone went and bought it and, oh, this is what happened.
All right, Mr. Smith, I want to be sure we hear from you. Any discussion, sir?
Well, I'm really befuddled that we're still stuck with the same 6 people who were at a 3-3 tie. I feel that there's been so much at stake and for so long on this case that I am in favor of a remand. I don't know exactly if we would say, as we did last December, item 1, 2, 3, 4. I don't know all of those, but I will have to vote against this motion, and I still remain in favor of the remand.
All right. Any further comments here, board members, before we call the vote? All right, the motion on the floor, duly seconded, is to approve the decision of the land use hearing officer. We'll do a roll call vote on that motion. Mr. Smith?
No.
Mr. Schwartz?
No.
Mr. Cornelius?
Yes.
Mr. Campbell?
No.
Vice Chair Bauman?
Yes.
And I'm a yes, and we have another 3-3 tie. So that motion fails. The only other possible action we could take is to remand. Does anyone care to make a motion to remand? I don't see anyone inclined to make that motion.
Mr. Chairman,
Hold on. Mr. Campbell, hold on.
Yes, I make the motion to remand and ask the land use hearing officer to revisit under the findings of facts 1, 2, 4, and 6.
All right, the motion by Board Member Campbell is to remand. Is there a second?
I second.
Board Member Smith seconds. Any discussion on that motion?
Mr. Chairman?
Mr. Cornelius, go ahead.
Mr. Chairman, I do support the finding. However, I don't want these applicants to continue to go in the circle that they've been in. So in the spirit of letting this move forward to a final resolution, I will support it coming back to the zoning hearing master for further analysis. Simply because I think that's the right thing to do to get this issue over and done. So I will support the motion to remand it.
All right, with that,
Mr.
let's,
Chair, this is Cameron Clark. May I just speak real
Go ahead.
quickly? Yes, Mr. Chair, I appreciate Mr. Cornelius's comments. I just wanted to let the board members know that if the board votes to remand this, obviously that is an action that is not a final disposition of this case. If the LUHO, whatever ruling the LUHO makes at a remand, it can still be appealed to this board, and at that time, this board would have the opportunity to either overturn or uphold the hearing officer's decision rather than simply remanding it or upholding it. So any vote that any of the members take today does not commit any member to any particular vote if this comes back to the board again. And obviously, as Mr. Cornelius stated, it keeps the process moving. I think the concern right now is that we have no immediate prospect of a seventh board member. And so that's all I had to say. Thank you.
all right, and that's a good reminder. If there is a remand, that will result in a new order of some type from the LUHO. And if that comes back to us, we will obviously review that new order. So having said all that, we'll do a roll call vote on the motion to remand. Board Member Smith,
Yes.
Board Member Schwartz,
Yes.
Board Member Cornelius,
Yes.
Board Member Campbell,
Yes.
Vice Chair Bauman,
No.
and I'm still a no. That's 4-2. The motion to remand carries and the case is remanded to the land use hearing officer.
Thank you very much.
Ms. Rodriguez, what else do we have today?
The approval of the minutes. We had on the agenda the April 2019, the February 7th, 2020, September 4th, 2020, and December 4th, 2020. However, the February 7th and the September 4th hearings were already approved on December 2020. So we just have the April 5th, 2019, and the December 4th, 2020.
All right,
Minutes.
Is there a motion to approve the minutes of the April 5, 2019 meeting?
Motion to approve both meetings. minutes.
Let's do one at a time.
Okay.
Ms. Bauman moves to approve the April 5, 2019 minutes. Is there a second?
I'll second, Mr. Chairman.
Motion seconded by Mr. Cornelius. Let's do a roll call vote, just so we have a clean record. Mr. Smith,
Yes.
Mr. Schwartz,
Yes.
Mr. Cornelius,
Yes.
Mr. Campbell.
I think I'm going to have to abstain because I don't think I was on the board then.
You can still vote.
All right, then I'll vote yes.
Vice Chair Bauman,
Yes.
and I'm a yes. Minutes are approved 6-0. Is there a motion to approve the minutes of the December 4, 2020 meeting?
Motion to approve the minutes of December 4, 2020, Mr. Chair.
Motion made by Vice Chair Bauman. Is there a second?
Mr. Chairman, I'll second.
Mr. Cornelius seconds. We'll do a roll call vote on the December 4, 2020 minutes. Mr. Smith,
Yes.
Mr. Schwartz,
Yes.
Mr. Cornelius,
Yes.
Mr. Campbell,
Yes.
Vice Chair Bauman.
Yes.
I'm a yes. Those minutes are approved by a vote of 6-0. Ms. Rodriguez, anything else for today?
Just to let you know, the next hearing is May 7th. I haven't received any appeals yet, but I will let you know if that's going to be canceled.
All right, Mr. Clark, are you still on the line?
I'm here, sir.
We have talked several times about having an update from the county attorney's office on an overview of the variance process and a piece of that dealing with the sunshine law and public records requirements. We've bumped that several times. I'd like to get that back on an agenda soon, please.
That sounds good. I'll coordinate with Mr. Rodriguez to have that added to whatever your next meeting date is. That way I can have a little bit of paperwork for the board members to be able to look at while I'm speaking.
All right, so can we get that from you at the May 7th meeting?
Yes, assuming that meeting is not canceled for lack of appeals, then yes.
All right, let's plan to have that. And then one more item administratively, there was some discussion at our last meeting about the circumstances of board members missing meetings and whether we can declare a vacancy. Mr. Clark, have you looked at that at all?
Sir, I spoke with Ms. Rodriguez about this week, and she noted that the subject member's term is about to expire anyway. And so that being the case, it would not be necessary. The member would just not be renewed.
All right, very good. That makes sense to me. Anything else to come before the board today?
That will be it.
All right, then we are adjourned.
Thank you.